June 19, 2020, a father and son were tracked into Tamil Nadu police station for allegedly keeping their shop open past COVID lockdown hours. 4 days later, both were tortured to death in police custody. The world watched George Floyd killing in America sparked global outrage and police reform. But in India, the Sathankulam case exposed something even darker. Systematic brutality that continues unchecked. Today, a 52-page order from the Madurai court weighs explosive new charges against 9 police officers. Criminal conspiracy under section 120B IPC. This is the full story from judgment itself. The evidence, the argument, and the uncomfortable question no one wants to ask. Why has India still not fixed the system that allows custodial death?
According to the CBI's petition on June 18, 2020, around 8:30 p.m., Sub-Inspector Balakrishnan along with Mutturaj scolded people outside Jayaraj's shop in Sathankulam. He warned, "I will return and peel off your skin if anyone is still standing here." Jayaraj, known for speaking openly, joked that police who behave arrogantly deserve to be beaten. The arrest was not part of routine lockdown enforcement. It was retaliation for Jayaraj's comment. Both were beaten in police custody over the course of 2 nights. The FIR filed by Sathankulam police claimed that the father and son rolled on the road and sustained injuries themselves, leading to their deaths. There were allegations of evidence being destroyed after the crime. This case stood out because CCTV footage was available, a rare occurrence in custodial death cases. Even in their severely injured condition following the brutal assault, Jayaraj and Benix were produced before a magistrate for remand. Reports suggest that the magistrate did not take their critical physical state seriously. Additionally, the doctors who examined them allegedly issued fit certificates despite their life-threatening condition. The magistrate and government doctor later claimed this was due to COVID-19 norms, which they said prevented them from following the standard procedure when allowing the father and son to be placed in custody. The court strongly observed that the accused, being educated government servants, abused their official duty, noting that where there is power, there is greater responsibility. It also found that the police acted with the deliberate intent of instilling fear among the public in blatant disregard of Supreme Court guidelines.
The government of Tamil Nadu, the union government, will use this case and the judgment of this strong judgment of the district court in Madurai arising out of the CBI investigation case to decide upon one definite thing: India needs an anti-torture legislation. It is too long that we have not had an anti-torture legislation, and it is high time, despite 4 universal periodic review recommendations, we have not yet ratified the UN Convention Against Torture. This is a wake-up call to the union government. It is a wake-up call to the Tamil Nadu government. If the union government doesn't do it, the Tamil Nadu government has all the right with this judgment in place. This is election time. Use this judgment to assure the people of Tamil Nadu.
In May 2020, George Floyd was killed in Minneapolis. His final words, "I can't breathe," sparked global outrage. Following widespread protests, police officer Derek Chauvin was convicted. US states passed police reform laws, mandated body cameras, and banned chokeholds. The Sathankulam case came to light in June 2020, the same year. The incident sparked protests and the Madras High Court ordered a CBI probe. The case became a national symbol of police impunity. Yet, 6 years later, the same court recently sentenced 9 officers to death in what it called the rarest of rare case. But here's the judgment's chilling detail. The brutality was not random. It was allegedly coordinated revenge. Globally, viewpoints shifted after Floyd's killing. In India, public memory faded. The outrage did not translate into systemic reform.
Custodial violence is not an ordinary murder because the state itself is responsible. The judge must have thought we must send out a very strong signal to the society, to the police force as such, that this cannot be tolerated. So that is the reason behind this death sentence. But is death sentence on a principle level? I wanted to ask whether it is a deterrent. What is the example? What is the international examples say? So there are many arguments against death sentence in principle. But these reasons for against death sentence can carry weight only when the society and the state are against the custodial violence as such, which is a serious thing in this case. What was the offense of these two people who were killed? They were just accused of violating COVID-19 guidelines. And that was also proved to be false allegations. Therefore, so the extreme nature of the violence, custodial violence, has shaken the conscience of the society.
While the nation focused on Sathankulam, reports confirm over 26 custodial deaths in Tamil Nadu alone since 2020. The judgment itself highlights the pattern: illegal pickups, targeted beatings, and cover-up attempts. Yet, India still lacks a specific law that treats custodial death as a distinct offence with provisions such as presumption of guilt against police officers, mandatory video recording of every interrogation and period of custody, an independent oversight board with prosecution powers. According to the 1997 Supreme Court guidelines on arrests, the police must issue arrest memos, conduct medical examinations, and provide legal aid. We also have NHRC protocols, but enforcement is weak and conviction rates in custodial cases remain abysmal. Why is this the case? Police patronage, a lack of political will, and a colonial-era police act that treats officers as unaccountable. The Sathankulam judgment proves that circumstantial evidence can build a conspiracy case, but only when the CBI steps in and the courts remain vigilant.
The 9 police officers in the Sathankulam case now face death sentence, a rare victory. But what about the families of other 26 victims in Tamil Nadu? This judgment shows the system can work when evidence is meticulously documented and high courts push for accountability. But justice cannot be a one-off. It demands a dedicated custodial death prevention act, compulsory body camera and station CCTV with tamper-proof storage, fast-track trials for all custodial death cases, police reform that remove political interference. Until then, every family waiting for the justice will ask the same question. The Sathankulam judgment forces us to confront who protect us from those sworn to protect us. For more such stories, keep watching The Federal.